All right, let's dive into a really fascinating clash between industry and the individual. We're going to unpack a 150-year-old court case that, believe it or not, still plays a huge role in defining your rights as a property owner today.
So picture this. You've got your home, your yard, and then a factory opens up nearby. And pretty soon, there's smoke and fumes drifting over, wrecking your garden. What are your rights? What can you actually do about it? It feels like a totally modern problem, right? Well, the answer comes from a place you might not expect.
Turns out the legal foundation for that very question was hammered out during a massive court battle, right in the middle of the Industrial Revolution in England.
And that brings us to the case of Mr. Tipping. On one side, you've got a gentleman who just bought his dream home, and on the other, a huge industrial copper smelting plant. I mean, it is a classic David versus Goliath story.
And just look at how fast this all happened. In 1860, Mr. Tipping buys his estate. Just 1 year later, the St. Helens Smelting Company fires up its furnaces right next door. By 1863, the damage is obvious. We're talking noxious fumes literally killing his trees and crops. And then, only 2 years after that, this local fight has shot all the way up to the House of Lords, the highest court in the entire country. So the entire case really hinged on this one legal concept, nuisance. Now, in legal speak, a nuisance isn't just something that's annoying. It's a very specific thing, an act that causes an unreasonable interference with your ability to just use and enjoy your own property.
So the big question for the court was this. Was the smelting company, with all its industrial smoke, creating a legal nuisance for Mr. Tipping? The company's argument was basically, hey, come on, this is an industrial town. What did you expect? And you know, for a minute there, it seemed like they might actually have a point.
But this is where things get really, really clever. The court came up with this brilliant distinction that just sliced right through what seemed like an impossible problem. How do you balance industrial progress against a person's private property rights?
Let's look at the actual words from the judge, Lord Westbury, because they're so important. He said, "There is a distinction between an action brought for a nuisance which produces material injury to the property and an action brought for a nuisance which is productive of sensible personal discomfort." This one sentence, this was the whole ballgame. It changed everything.
And this chart breaks down exactly what he meant. It's so smart. The court basically split nuisance into two different buckets. In one bucket, you've got personal discomfort, things that just offend your senses, like awful smells or constant loud noises. For that stuff, context is key. A smell that's a nuisance in a quiet suburb, well, it might be totally fine in a heavy industrial zone. But in the other bucket, you have material injury to property. We're talking actual physical, tangible damage, dying trees, poisoned crops.
And here's the absolute kicker. The court said that when it comes to physical damage to your property, the neighborhood doesn't matter at all. It's completely irrelevant. Pollution that causes real, tangible harm is unacceptable, period, full stop.
And with that powerful, game-changing distinction, the outcome was crystal clear. Mr. Tipping won. The industrial giant had to pay up for the damage it had caused.
Okay, so a guy in a fancy hat won a lawsuit a century and a half ago. Why should we care today? Well, it turns out the legacy of this one single ruling is enormous, and it affects all of us right now. I mean, think about it. For over 160 years, the basic idea set down in St. Helens versus Tipping has been a cornerstone of the law in tons of places around the world. Its logic is just that solid. So let's trace the ripple effect, right? This old case is literally the bedrock for a lot of our modern environmental law. It draws a clear line in the sand about our property rights, and it specifically protects homeowners from direct physical damage from pollution. It's the standard that courts still use today when they have to weigh industrial progress against our individual rights. And yeah, it flat out answers the question we asked at the very beginning. If a factory's pollution is causing material injury to your property, you've got a case. It doesn't matter where you live.
The Tipping case drew a really clear line for physical damage, but it leaves us with a much trickier question for our own time, with all kinds of new pollution, from noise to light to even our data. In the 21st century, where do we, as a society, draw that line between progress and protection?